Okay, and we're back. This is the lecture video for assignment number 36, where we will begin talking about substantive due process, the protection for reproductive autonomy. And as we think about the issue of reproductive autonomy, we're going to be talking about three different areas. We're going to start today with talking about the right to procreate, and then we will talk about the right to have access to contraception. And then we will finish up in our last class talking about the right to an abortion. In the last video, we talked about how the court has recognized certain rights to be fundamental rights, certain unenumerated rights to be fundamental rights that are protected under the protections for our liberties in the due process clauses. We started by talking about the right to marry, the right to choose the person that you wish to marry, or simply the right to be able to marry as a fundamental right. We then moved on to talk about the right to have custody of your children and the right to control the upbringing of your children. And we are going to pick up with this list here to talk about the right to procreate. And here we are going to begin by talking about the 1927 case of Buck versus Bell. This is a case in which the Supreme Court, in one of the last opinions ever written by Justice Holmes, upheld a forced eugenic sterilization program. And it is definitely a case that has always really fascinated me. At the time that Buck versus Bell was decided, we had more than 30 states in the United States had some sort of forced sterilization law. There were only 2 states, however, that really enforced them with any kind of regularity, and those were the states of Virginia and California. More than 60,000 people were sterilized under these programs, and this was a practice that continued in the United States into the 1970s. Men could be and were sterilized under these programs, but predominantly it was women who were subject to the forced sterilization. There was one study that found of the people who were forcibly sterilized in the United States, 99% of them were women and 60% of them were Black women. So it was an action that was most commonly taken by the government against women of color, a large number also of Puerto Rican and Native American women. Much of our country's immigration law actually started out as a form of eugenics. There were large movements to limit immigration from people who were Jewish, from Italians, Asians, different groups who were deemed, at least at the time, of course, to be considered genetically inferior. Now, the laws that allowed for forcible sterilization varied from state to state, but as a general rule, they allowed the government to sterilize people who were determined to be things like insane, what they called idiotic or imbecilic or moronic, people who were epileptic could be forcibly sterilized, alcoholics, drug addicts, people who had disabilities like blindness, or they were seriously hearing impaired, people who were determined to be dependents of the states, orphans, homeless, people who at the time they called ne'er-do-wells, tramps, or paupers would be forcibly sterilized. And it was something that was very commonly used on unwed mothers, women who were victims of rape, prostitutes, people with other various kinds of traits that at the time were determined to be undesirable. So this particular case is about a woman named Carrie Buck. Carrie was born to an unwed mother and she was placed in foster care. Her foster family withdrew her from school in the 6th grade and had her work as their servant. When she was 17, it was believed that she was raped by the nephew of her foster family and she became pregnant. Her foster parents sent her away to have the child, and it was then that she was institutionalized. There are transcripts of her commitment hearing, and they focus on things like her, quote, loose morals, unquote. One of the commentators at her commitment hearing, or a commentator who has studied her commitment hearing, talked about how it really did seem that it was the illegitimacy that was bothered the state, the fact that both her mother had had a child out of wedlock and then so had Carrie. And her mother, Carrie's mother, Emma, was indeed in the same institution where Carrie was ultimately placed. They were both tested on what were these fledgling IQ tests at the time, and they were both determined to be what they called feeble-minded. These were, at the time, these very popular tests that were admitted, were attempts to measure some form of genetic biological intelligence. So Carrie had a daughter named Vivian, and when she was 7 months old, Vivian was declared by a social worker to also be quote unquote feeble-minded. To determine how a 7-month-old baby could be feeble-minded, the social worker did a test. They held a coin in front of Vivian and noted that the baby didn't look at the coin, but instead was distracted by other things, and therefore supported a finding that the child was feeble-minded. Here's a quote from some of the transcript of the social worker's testimony, where she is talking about Vivian. And the social worker says, "It is difficult to judge probabilities of a child as young as that, but it seems to me not quite a normal baby. I should say that perhaps my knowledge of the mother may prejudice me in that regard. There is a look about it that is not quite normal, but just what it is, I can't tell." So Vivian was ultimately adopted by Carrie's foster parents, and the child, Vivian, actually died when she was 8 years old in some kind of mysterious death that seemed to have involved some sort of fall. Later, scholars who have looked into the story of Carrie and of Vivian investigated Vivian's school report cards and showed her to be a child of average normal intelligence. So Justice Holmes writes the opinion of the court here. This is an 8-1 decision, and the question for the court was whether or not Virginia's forced sterilization law violated Carrie Buck's constitutional rights under the 14th Amendment, either the Due Process Clause or the Equal Protection Clause. And Justice Holmes, writing for the court, declares that procreation is not a fundamental right. He says that the state here has a strong interest in protecting the health and welfare of its society. And he also talks about how it is, quote, better for all the world to sterilize instead of waiting to execute their offspring for a crime or letting them starve for their imbecility. And here's where he has the infamous line where he says, 3 generations of imbeciles are enough. So Justice Holmes here sees very little restraint on the ability of the majority to be able to pass the laws that it deems to be fit. And indeed, this is consistent with his dissent in the Lochner case, if you'll recall, where he said that the Constitution does not enact Mr. Herbert Spencer's social statics. He said that if his fellow countrymen want to go to hell, he will help them. It's their job. So he was deferential then to the political process and the laws that it's produced, and he is being deferential there, although he seems to be being more than deferential to these forced eugenics laws. He actually seems to think not only are they legal, but they are actually quite desirable. But nonetheless, it does raise the question of whether or not there is something different with what was going on in terms of the court of Justice Holmes deferring to the legislative bodies, to the political process in the economic regulations that it enacted, as in Lochner, and these other employment or other economic laws, versus what the state is doing here when it comes to a law that results in the forcible sterilization of Carrie Buck. Are they the same? Should the court defer to the legislative process in both cases? Should it do so in neither? Or should it do so in one of these but not the other? And if so, then we of course need to figure out why, what the difference might be. It was only 15 years later, however, when the court seemed to take a different view of the right to procreate in the Skinner versus Oklahoma case, now 1942. And here the court is considering a state law that requires the sterilization of anyone who is convicted of 3 offenses of moral turpitude. So Justice Douglas is writing the opinion of the court here, and he says that this case involves a right that is of the most sensitive and important area of human rights, this right to have children, the right to have offspring. And the court strikes down this law on the basis that, in this case, they put it in the category of equal protection, that they were making different categories based on crimes that are considered to be moral turpitude or not. And again, this distinction is not important for our purposes, but the court strikes down the law and says that the right to procreate is a fundamental right. And Skinner versus Oklahoma was a unanimous decision. It was 9-0, whereas, as I said, it was just 15 years earlier when the court, by a decision of 8-1, had upheld the forced sterilization of Carrie Buck. So the question is, what happened in those 15 years that might have affected how the court viewed the right to have children, as whether it should be considered a fundamental right and protected by the Due Process Clause. And it seems that most likely what happened is that World War II happened, and the concept of eugenics fell out of favor during World War II. So this slide shows a piece of Nazi propaganda that shows a couple here with their baby, and on the shield it talks about one of Hitler's first acts in office, called the Law for the Prevention of Hereditarily Diseased Offspring. It was a compulsory sterilization program that ultimately went on to involve the sterilization of more than 400,000 people. And my high school German is not fantastic, but on the top here, it tells us something along the lines of we stand not alone, right? Germany is saying we are not alone in having our forced sterilization or compulsory sterilization program. It shows the flags of other countries who have similar programs. And right here is the United States, probably not something that many viewed with much pride, certainly as the war continued. So by 1942, this view of eugenics, this view of sterilizing people against their will, had a very different reaction from the court. Now, this case doesn't overrule Buck v. Bell explicitly, but does subject these rules to strict scrutiny. This is why we did continue to have these forced sterilization laws like the one with Carrie Buck into, as I mentioned earlier, the 1970s. And there continue to be controversies about government-ordered sterilization, usually though through the claim that it was indeed voluntary. There have been several cases that were brought based on sterilization being part of a criminal plea agreement. In 2013, there was a case where it was revealed that the state of California had sterilized 148 female prisoners between the years 2006 and 2010. And critics charge that the women in that case were either coerced into agreeing to the operation, or else they were not given informed consent about what exactly was going to happen. And this whole controversy eventually led to the passage of a bill that, in that state at least, that banned the practice. So we've continued to add to our list of rights that the Supreme Court has recognized as fundamental rights that are protected by the liberty provision of the Due Process Clause, starting with the right to choose the person you're going to marry, then the right to have custody of your children, make decisions about your children's upbringing, then the right to have children. And that brings us then to the question of whether or not it is a fundamental right to then not have children, starting with the idea of a right to contraception. Now, the key case here is the 1965 case of Griswold versus Connecticut. And this case involves a Connecticut statute that prohibited the use of any drug, medicinal article, or instrument in preventing conception, or to give any advice about this. And this is one of many laws that had been enacted that were known as Comstock laws, that were passed, named after Anthony Comstock, who was the founder of a group called the New York Society for the Suppression of Vice. So this is actually the New York Society for the Suppression of Vice's actual shield here, its motto, which I've always found to be sort of hilariously crazy, where they're like literally putting someone throwing books on a fire into their emblem. But nonetheless, this was an influential organization that led to a number of laws, including this one that was enacted in 1789. Now, it was virtually a dead letter law. It was never really enforced. We actually talked about this law back when we talked about standing in the case called Poe versus Ullman that you may recall. But ultimately, we did end up getting the state prosecuting a doctor and the director of Planned Parenthood, a woman named Estelle Griswold, under the law for giving advice to married couples about contraception. The case goes to the Supreme Court, and the Supreme Court strikes down the law by a 6-2 margin, but we end up with 4 different opinions from the justices. Justice Douglas writes the opinion of the court, and he tells us that this law banning access to or the ability to give advice about contraception violates what he calls the right to privacy. The question is, what does he mean by this? What are we talking about when he talks about that we have a constitutional right to privacy? And at least according to Douglas, it seems to be that the right to privacy means that there are just certain things that the government shouldn't be able to intrude upon. And this includes the privacy of the marital bedroom. So he seems to relate the right to privacy to the area of the home, to the relationship of marriage. It seems to be related to him to the right to have control of certain private information. But what Justice Douglas, at least, is not doing is declaring that there is a constitutional right to have access to contraception. He's not relying upon the idea that there is a right of reproductive autonomy in the Constitution. Instead, again, he is centering this in this idea of a right to privacy, which raises the question of where does Justice Douglas find the right to privacy in the Constitution? And he tells us that the right to privacy can be found in the penumbras formed by emanations of the Bill of Rights. So a penumbra, if you don't know, is sort of the partially shaded outer region of a shadow that is cast by an object. So when you think about an eclipse, there's sort of the arch of light that can be seen around the eclipse. That is the penumbra. And so what he says is that if you look at the Constitution, you can see a number of different things that touch on the idea of a right to privacy. First Amendment has the right of association. You have this right to be able to choose the people you are going to associate with, that this is a right that we have recognized as part of our First Amendment rights. He talks about the Third Amendment, that you have a right not to have soldiers quartered in your house during a time of peace. He says the Fourth Amendment protects a right to privacy, that you have a right not to have the government have an unreasonable search or seizure of your home or of your private property, that this is a privacy interest. He talks about the Fifth Amendment, how it has a prohibition against self-incrimination through either your testimony or your own papers. And then he also talks about the Ninth Amendment, which we have discussed, that the Ninth Amendment tells us that we do retain these other rights, these unenumerated rights. So he says when we look at these, we see this larger protection for right of privacy. And we sort of put it all together, maybe squint our eyes a little bit, and we see this right to privacy. I once read a commentator who talked about Justice Douglas's opinion here, and he said that he's sort of like a cheerleader, kind of skipping along through the Bill of Rights, saying, give me a P, give me an R, give me an I, what's that spell? Privacy. That he sort of sees a little bit of it here and there and kind of puts it all together to say this is a constitutional right that we have. So the question is, why is Justice Douglas doing his constitutional analysis this way? What he's not doing is saying that the right to privacy is a privilege that is protected for us under the Privileges and Immunities Clause of the 14th Amendment. That could have been because the slaughterhouse cases still had not been overruled. And so we had that very narrow and continue to have that very narrow view of what our privileges and immunities protections are. He also doesn't say that the right to privacy is a liberty that is protected by the Due Process Clause. Why doesn't he say this? Well, perhaps it's because he didn't want to go in the direction of substantive due process. The effect of concern about Lochner and falling into the issues that were deemed to be problematic in the Lochner era. Now, we still have the due process, a form of substantive due process for incorporation purposes, but Justice Douglas here doesn't embrace the 14th Amendment due process clause when it comes to recognizing this this unenumerated right of privacy. Now, subsequent courts have reinterpreted Douglas's opinion in Griswold as being a substantive due process opinion, saying that the liberty provision of the due process clause protects the right to have access to contraceptives. Yet it's really quite clear that that is not the basis for what Justice Douglas is doing here, that he is finding other parts of the Constitution to be the repositories for this right of privacy. Okay, so that's Justice Douglas writing the opinion of court, telling us that we have this penumbra of constitutional rights. We also have a concurrence written by Justices Goldberg, Warren, and Brennan. And they really focus, while they agree with the outcome that there is a constitutional violation with this law, their focus is on the Ninth Amendment, telling us that the Ninth Amendment says that the court, we have other rights that are retained, that the court can protect these other rights as a constitutional matter. So basically chiming in here to say that it's just not any argument to say that because the Constitution doesn't mention privacy explicitly doesn't mean that it is not protected. So this reliance here on the Ninth Amendment is a reliance to say that the Ninth Amendment makes it permissible for the court to protect other rights, although it doesn't necessarily give us much guidance on what those rights are or how the court should be determining them. We then have Justice Harlan, who is concurring, and he doesn't feel the need to sort of dance around perhaps the way he thinks Justice Douglas might be doing. Rather, he says that this is indeed a right that is implicit in the concept of ordered liberty and therefore protected by the Due Process Clause of the 14th Amendment. He says we don't need to be able to point to all of these other parts of the Constitution. Justice White is also finding the law to be unconstitutional as a form of substantive due process. He, however, doesn't seem to think it's even really necessary to apply the heightened standard that we would get from fundamental due process, because this law fails as being arbitrary and capricious and does not further even a legitimate state goal. Then we have Justices Black and Stewart, who are dissenting. And they tell us that, well, they think the law is unwise and offensive and even silly, that they say there is no constitutional right of privacy. And they're concerned that saying that the court should not be protecting rights that aren't stated anywhere in the Constitution. So the dissents here are raising this underlying question about constitutional interpretation. Should the justices be able to, should they engage in the practice of interpreting the Constitution in order to recognize and protect fundamental rights that aren't mentioned explicitly in the text of the Constitution? So Griswold is often considered to be really the crucial case when it comes to modern substantive due process. This idea that we have a concept of the liberty that is protected in the due process clauses that include these rights of privacy, meaning these rights to have, to be able to make these personal, intimate decisions, these areas that the government should not be able to intrude upon, at least not without a compelling government interest. Including rights like the right to have children or to not have children, and into creating your family, whether it's through marriage or through having children or having custody and making decisions about your children. Are all of these a type of liberty that the court should be protecting through the constitutional framework, even though they are not mentioned in the text of the Constitution? Is this unjustified judicial activism on the part of the court? Or is this an appropriate and indeed desirable activity by the court, that it involves the court recognizing what kinds of rights are at their core, what it means to be a free and autonomous person? Basically, anytime there has been a Supreme Court nomination, a confirmation hearing in the modern era, the nominee is asked about his or her opinion about the Griswold decision. And for quite some time, it was very universal that the nominees would express their support for the court's opinion in Griswold. Justice Thomas, for example, at his confirmation hearing said that, quote, "My bottom line was that I felt that there was a right to privacy in the Constitution, and that the marital right to privacy, of course, is at the core of that." Justice Alito said, I agree that Griswold is now, I think, understood by the Supreme Court as based on the liberty clauses and the due process clause of the 5th and 14th Amendment. I do agree with the result in Eisenstadt, which was the case that followed Griswold, declaring unconstitutional a Massachusetts law that prohibited the distribution of contraception to unmarried people. And in Eisenstadt, the court quite clearly does this as a matter of substantive due process, as a liberty protection for reproductive decision-making. Chief Justice Roberts, in his confirmation hearing, said that he agreed also with the Griswold court's conclusion that marital privacy extended to contraception and the availability of that. But Justice Gorsuch, when he was asked about this in his confirmation hearings, did not quite so explicitly express his agreement. And in fact, what he said when he was asked was that he said, so Griswold, Senator, as you know, held that the 14th Amendment Due Process Liberty Clause provided a right to married couples to the use of contraceptive devices in the privacy of their own home. And then Eisenstadt versus Barrett extended that to single persons. Those are the precedents of the United States Supreme Court. And that's all I have for you for the readings on this assignment. I look forward to talking with you all about this on Monday. Thank you.